Hello, this is Mr. Fredericks, obviously. Welcome to my home office. It's time for Chapter 2, Sections 3 and 4 lesson. Don't want to go through this every time, but as you know, you're going to get some of your lessons on video, so we have a chance of getting the entire curriculum covered. Okay, so let's get after it. The information I'm going to present today is found in Chapter 2, beginning on page 31, which is about midway through the chapter, to the end of the chapter. I'm also going to meander around a little bit, skip around a bit more than I normally do in the chapter, just to make it easier for you to understand and make sure you get the big ideas and don't get lost in some of the detail. Okay, so the overall chapter 2, is on the Constitution, and the previous parts were on drafting the Constitution, and this part is going to be on ratification or approval of the Constitution, issues at hand, and then debates about the Constitution as it was sent to the various states for approval. So let's go ahead and get going. I'm going to be referring to some notes over here as I go. I'm not really using the screen share function that much, but if I were, perhaps you would have the lesson outline opened, and hang in there with me a second. I am going to show you what I would be sharing if I had it open quite a bit. And this would be the document that I would start to share right there, but I'm not sure you're even seeing it because I am not sure I am using the screen share function properly. Let's try it one more time. Share, add background, Windows. Boom, is that going to give me it right there? All right, that's what you're supposed to be seeing. Thanks for hanging in there with me. But you would be all the way down to chapter 2, but we've covered the first two sections in class. So I'll get to the new content in a minute. Hang with me. You're basically picking up information right here. Ratification debates, inclusive of key principles um, for and against the Constitution, etc. In fact, let me change my mind and let's do this video in and out of the screen share. All right, so first thing I want you to remember is that the founding fathers sought to create a republic rather than a democracy, because the republic, in their view, a situation where the government is put in the hands of elected officials, gave them a filter against impulsive actions of the people that a true democracy might be prone to, and protected uh, the minority from being taken over by an oppressive majority, with the biggest concern of James Madison and others being the protection of a wealthy, landed aristocrat minority in a true democracy being run over and having their wealth taken away from them by the majority of people who would not be that wealthy. So they opted for a republic. The Constitution gives us a representative democracy, which is a republic. Another reason for it was just it was practical. It was hard to have a direct democracy where the people would vote on each law when they were spread out over the whole Atlantic seaboard of North America and 13 different states. And it would be equally as impracticable today. However, what I'm using right now, the computer, might actually make it workable for the first time in 200 years, in that you could theoretically do away with Congress making our laws and put all of our proposed laws, bills, on a website and have the people have a security code, get in there and vote. when it was time to vote. But I don't think anybody wants to move that direction, and they would think that would be preposterous, and James Madison would be particularly scared of it. All right. So also know that the new Constitution in Article 3, where it discusses the judicial branch, to most people's reading, created the power of judicial review, the right of the courts in the country to declare laws unconstitutional. Now, there is somewhat of a debate whether that was universally understood, but it was doubled down on in 1803 with the famous case of Marbury versus Madison, which establishes judicial review once and for all. And in our in our class, we're going to be looking at many decisions of the Supreme Court throughout the whole semester, and usually we're looking at judicial review, whether the court is going to determine something to be constitutional or unconstitutional. So the major debate about ratification of the Constitution came over whether or not we were creating with the Constitution a new central government that was too powerful, conceding that the one under the Articles of Confederation wasn't powerful enough. And if it is too powerful, will it be robbing the states of powers the states ought to have? So it's a battle, which I'll mention later in the lesson, between those who advocated a significantly stronger central government and those who probably conceded the fact that under the Articles of Confederation, the central government was not powerful enough, but they were very concerned about giving too much power to a national or central government and were more bent on preserving or reserving state powers. So the next little subsection there says things delegated to the national government. And notice how I have the word delegated in quotation marks. There's a reason for that. The 55 men who meant at Philadelphia the right to Constitution called the new powers given the stronger national government delegated powers. To me, that word is meaningful. It's kind of like pregnant with meaning. For something to be delegated, it has to be given over by somebody who had it in the first place. So now we're going to touch off an age-old debate as to who delegated the national government its powers. Was it the individual state legislatures, or was it the people of those states? This is significant at certain junctures of American history. Nonetheless, the powers of the national government are called delegated. Remember the word delegated, meaning powers given to the national government. Now, there are three kinds of delegated powers. One of them is called enumerated powers, also called express powers. Okay, these are powers that are specifically written in Article 1 of the Constitution. They include things like the power to tax, the power to declare war, etc. Just there's no doubt about it. The national government through the Congress has the powers to do these things because they're specifically stated. Your definition is up there on the screen. Powers given to the national government, all numbered out largely in Article 1 of the Constitution. But in addition to that, there are implied powers. Implied powers comes from the fact that after the list of enumerated powers, there is something called the necessary and proper clause, aka elastic clause, and it says Congress can do what is ever necessary and proper to put the aforementioned powers into effect. So you'll remember from history last year, Hamilton interpreted this necessary and proper clause, aka elastic clause, as to be very elastic to give the national government a large sphere of power, and in the argument we looked at last year, the power to erect a corporation, and in that case, a bank. But Jefferson said, no, necessary and proper should be read differently, and it should restrain the government into a very specific sphere of powers. So implied powers is always a matter of controversy. And then there are inherent powers. We have a big controversy in our country today over what our border policy should be. But nobody denies that the right to control the border is a power of a national government. Some believe it ought to also be the power of state governments, or if the national government isn't doing it, the states should pick up the slack and do more of it. But no one denies that to control its borders is a power of every country. It doesn't have to be stated in the Constitution. Therefore, it's there naturally, which is what the word inherent means. Then there are powers known as reserved powers. These are powers kept to the states. The most specific statement of reserved powers in the Constitution is the 10th Amendment. It says those powers not delegated to the national government nor denied the states shall belong to the states or to the people. Now, those advocates of states' rights during the ratification debates, the anti-federalists, took this super literally, like if the Constitution doesn't say the national government should do it, if it's not enumerated, then it's also not delegated and it therefore is reserved or belongs to the states. That doesn't leave hardly any room for implied powers, but that is an interpretation of the 10th Amendment, and one that Jefferson leaned on a lot until he became president and then had to use implied powers to make sure he got big stuff done, like purchase the Louisiana Territory. Another sort of vocabulary word you need to know about the powers in the Constitution that were somewhat controversial during this time of debate as to whether we should ratify it or not are called concurrent powers. Concurrent means two at the same time. Okay. So these are powers that are shared by the national government and the state governments. After 1913 and the passage of the 16th Amendment, both the national government and the state government have the power to tax incomes. So if you live in a state that has income tax, and not all the states do, Arizona does, you have to pay an income tax bill to Washington, D.C. through the IRS, and you have to pay one to Phoenix, Arizona through the Arizona Department of Revenue. It's an example of a concurrent power. Your book does not use the term exclusive powers, but I wanted to include it there. That would be any power that is only the power of a national government, like the power to declare war, or a power that is only the power of a state government, like to issue a driver's license, for example. Okay, separation of powers, the sharing of constitutional authority by multiple branches of the government. This is one of the supposed great advantages of the new Constitution, and one of the points Federalists, those in favor of ratifying the Constitution, pointed out the most. The era of the Constitution was an era when people were concerned about government overreach, as we would say today, or encroachments on people's freedom, or the protection of liberty by a government that might morph into something that is despotic, meaning having too much power, or totalitarian, basically the same thing. They thought one of the great protections against this was separation of powers, that our government is divided into multiple branches, and obviously the basics, the very basics of American government is to know that the legislative branch, Congress, makes laws. The executive branch, the president and all his subordinates, thousands of them, put the laws into effect, and the judicial branch interprets the law, tells us what the law means. Also built into the Constitution are a system of checks and balances. In layman's terms, that would be how one of the branches can restrain the power of other branches. Your textbook definition is right there on the screen in front of you. Constitutional ability of branches of government to limit each other's power. For example, Congress can limit the power of the president by withholding funds for putting programs into effect, because the budget has to be approved in the Congress. The president can limit the power of Congress by vetoing bills that Congress might send his way, but then the Congress can turn around and check the executive by overriding the veto by 2/3 vote. The courts can restrain both the executive and the legislative branch by declaring laws that they pass to be unconstitutional, or in other words, the power of judicial review. And as we go through a whole semester of government, we'll see checks and balances at play all the time. And we'll also consider controversies where people are claiming the checks and the balances aren't working, and one aspect of the government is exercising excessive power. The dividing of governmental powers up into branches and having them check each other was a key component of the writings of a political philosopher by the name of Montesquieu. And he specifically addresses this in a book called Spirit of Laws. That book and the writings of Montesquieu in general highly affected James Madison, the principal writer of our Constitution. So we see facets of Montesquieu preferred government built into our Constitution. The founding fathers were also concerned that government might become ineffective if it was divided up into hostile groups trying to get only their point of view turned into law. The founding fathers, like Madison, would have called these factions. They are pretty darn close to what we call political parties today, a group with distinct political interest. In Federalist Paper number 10, a required assignment in this class, Madison argues that the beauty of the new Constitution is that it allows factions to exist, because factions come about because people are free, they have liberty, they have the right to have an opinion, but it controls some of their damaging effects. And he uses the famous saying, or famous as a result of him writing Federalist Paper number 10, that liberty is to faction as air is to fire, meaning that we would no more want to get rid of the people's ability to form their own opinions, to control faction, because faction is sometimes argumentative, contentious. I am filming this video on the day of a presidential debate. I'm sure President Biden, as of today, and candidate Trump, former President Trump, will get very contentious, and they will be representing very divisive views of the two parties tonight. Madison says that's okay as long as the system controls it. His point is we don't want to get rid of faction any more than we'd want to get rid of air to control the destructive elements of fire. You get rid of air, there's no oxygen, there can't be any fires, but there also can't be any life. And in saying liberty is to faction as air is to fire, Madison is saying the only way to get rid of faction fully is to not allow people to have differences of opinions, or in other words, to get rid of liberty. And in that case, the remedy is way worse than the disease. All right. So I've mentioned this several times already, and it's pretty common knowledge to anybody who's taken American history. Those who supported approval or ratification of the Constitution became known as Federalists, and those who were against it became known as anti-Federalists. Please remember that Federalist prior to 1789 was that contingency of people who were strongly in favor of the Constitution. It later morphs into an official political party under Alexander Hamilton. But at this point, we're just talking about those who favored the Constitution. And the reason they did it is because they wanted a stronger national government. There's your textbook definition in front of you. Anti-Federalists are those who favor weaker national government and thought the new Constitution robbed the states of too much power. Today, it's hard for us to imagine that the Constitution almost did not pass, but the vote was pretty close in most states, and most significantly, the Constitution would ultimately pass by one vote in the state of New York. That's not a lot in one of our most important states. The Federalist Papers were written to convince the people of New York to tell their state legislatures who were attending a ratification convention to vote in favor of the Constitution. And the anti-federalist papers were written to tell those at that same convention to vote against the Constitution. Each group tried to form coalitions. Coalitions are still important in government today, just alliances of groups, people who could come together on an issue, maybe for a variety of reasons. So in Federalist Paper 51, Madison discusses the advantages of the way the new Congress is set up, and he was able to bring several groups into an alliance to support the Constitution as a result of that. The Constitution does specifically say the national government cannot do some things, or it's prohibited certain powers. Here are the three most commonly referred to prohibited powers. One is to deny a person the right to habeas corpus. Habeas corpus means to have the right to appear before a judge as an arraignment if you're accused of a crime and at your own trial. Literally in Latin, it means produce the person, produce the head. It's in order to produce an accused person before a judge. Congress can't deny it. So there's a kind of a double negative there. It's a power prohibited to Congress to pass any law that would deny an accused person of the right of habeas corpus. Congress can't pass a bill of attainder. A bill of attainder is when a legislative act, like an act by Congress or an act by a state legislature, declares somebody guilty of a crime. That's not their job. That would explode separation of powers. It's the job of courts. So Congress can't pass any law that declares a person guilty of any kind of crime without that person having a trial, and the trial needs to happen in the judicial branch. Congress can't pass ex post facto laws. Ex post facto is Latin for after the fact. Okay, a law that makes an act criminal, even though it was legal when it was committed. So, since we're all drivers, or pretty much all of us are drivers, let's give an example like this one. If I were to be driving 65 miles an hour today on the 101, and I got flashed, but the posted speed limit is 65 miles an hour, so I'm within the limit, and it's not a crime today. If our state legislature would say there's too many accidents on the 101, people are going too fast, so we're going to lower the speed limit to 55 miles an hour. They can't then mail me a ticket for going 65 today when 65 was legal. That would be an example of an ex post facto law, and it would be denied by the Constitution. No state could get away with doing that, nor could the national government. At one point, you won't remember this. In the 1970s, when I was your age, we had a national 55-mile-an-hour speed limit, even on interstate highways where the speed limit is 75 and up to 80 miles an hour today. You could not go more than 55 because we were in an energy crisis and we were trying to save fuel in the 70s. One time on my way back to college in Flagstaff at NAU, the Harvard of Flagstaff, I got a ticket for going 62 miles an hour on I-17, where the speed limit today is 75. Darn. Okay, moving on. Some of the states made it pretty clear that they were not going to ratify the Constitution in their various ratification conventions unless a Bill of Rights was added to it. It seemed to be a deficiency, and they feared that because it wasn't there, it was a power grab by the national government. The Bill of Rights basically protects our civil liberties. Like, for example, the Second Amendment, the right to own a firearm, and all the different protections of the First Amendment, freedom of speech, press, the right to peaceably assemble, the right to redress the government with grievances, and the two clauses about freedom of religion. None of that was in the original draft of the Constitution. Ironically, some of it had been in the Virginia plan that Edmund Randolph had recommended, but as you'll recall from previous lessons, the Virginia plan was not satisfactory to small states. Therefore, ultimately, in the plan of representation, we adopted the Connecticut Compromise by Roger Sherman. So, since none of the other plans, like Roger Sherman's plan or the New Jersey plan, included a Bill of Rights, only the Virginia plan did, and it did not pass, it had to be added to the Constitution. So, basically, what happened there is James Madison and the members of the convention made it clear to the states if they in good faith ratified the Constitution, the first order of business of the new government would be to pass a Bill of Rights. And historically, we have the first 10 amendments, the Bill of Rights, operational very early in the 1690s. The Constitution was a bit controversial about what it said and didn't say about slavery. However, it was purposely evasive or vague as to engender Southern state support. The Constitution does not use the word slavery. Let me rephrase that. It refers to slavery with perhaps not using the exact word. It might say slave in it in one section. Here's what the Constitution does address. It says that the importation of new slaves should cease as of December 31, 1807. So, in other words, no new slaves are brought into the country after 1808. And it also has clauses about how one state is responsible to deliver fugitives from another state to the state from which the fugitives fled. That could be relative to any fugitive of a crime, but it's generally understood to be there for runaway slaves. And then obviously the 3/5 compromise in determining how much of a slave population is counted towards the total population of a state, which influences the amount of representatives in the House, is included in Article 1. Those are the only three things the Constitution says or infers about slavery. Most of the founding fathers believed that in 10 to 20 years, slavery would die out because it was becoming increasingly less profitable. But as you'll remember from your American history class, that all changed with Eli Whitney's invention of the cotton gin. All right. That's pretty long. It's already a 27-minute video, and I don't like these videos going that long, but we have another section to cover, and that's democracy and the Constitution, post-ratification debates. So some right away said the Constitution doesn't give enough protections or involvement in the government to women, and that might be a reason to not ratify it. That did not prove to be a major issue at the time. Basically, John Adams and the others ignored Dolly Madison's advice, which was to remember the ladies. And the Constitution was basically debated and drawn up by 55 males, and I might say 55 white males, not all of which, but most of which were quite wealthy. So some say the document wasn't representative of the American people then and isn't today. All right, Charles Beard is a historian who writes mostly about political matters, and his interpretation of the Constitution is that it was largely motivated by the economics of the 55 delegates, most of which, as I said a moment ago, were wealthy. It's a document that maintains a level of democracy, but not too much democracy, by putting the emphasis on being a republic. So a majority of non-wealthy people can't grab power from a minority of wealthier people. That is an interpretation of the Constitution. And therefore, at the time that there was debates over the ratification of the Constitution, some would argue that it overly represented wealthy people and didn't represent people of average means enough. At the time of the Constitution, how we understand equality today was not how they understood equality then. We're going to go into this much deeper in in a future chapter, but the founding fathers were largely concerned with um, equality of opportunity, that people had a chance to better themselves in American society. At that time, not inclusive of slaves in the South. Um, Today, the debate has morphed a little bit towards an emphasis on equality of results, making sure all people groups are equally represented in all areas of American life, particularly politics. But equality wasn't a main sticking point or discussion point or point of emphasis at the time the Constitution was written. Liberty far exceeded equality as a national goal, as mentioned in chapter 1. We're almost done here. Um, the founding fathers were trying to create a document that would give us a stable society, yet be able to respond to change. So I want you to think about this. 10 of the constitutional amendments occurred in the first Congress, the Bill of Rights. From that point on, we've only amended the Constitution 17 times over now almost 240 years, and one of those amendments undoes an earlier amendment. The 21st Amendment does away with the 18th Amendment on prohibition. So, in essence, we've only changed the Constitution 15 times. That's not a lot. So, I think the founding fathers should be applauded for achieving this goal of creating a stable government that can change when necessary. Um, a famous lawyer once said, his name is Pound, I don't remember his first name. He said, the law must be stable, but it cannot stand still. And that's kind of what they were trying to achieve. Um, in your book, it talks about various modern opinions on the Constitution and its current effectiveness, et cetera. And those are all over the place. But we're here just concentrating on those who supported the Constitution at the time of its ratification because they wanted a stronger central government. You might call them, as the book nicknames them, nationalists. And those who opposed the Constitution because, for a variety of reasons, like those that are stated in the anti-federalist paper entitled Brutus that we either have read or will be reading, um, gave too much power to the national government and robbed the states of power. So anti-federalists could be called states' rightsers if you wanted to. Um, the book, this is kind of a seemingly out of place comment late in the chapter, but it basically says, did the founding fathers, in writing a constitution that created a Congress that would act slowly and deliberately on purpose because they didn't want it to overreact to things, did they create a government that goes so slow that it's often in gridlock? In other words, um, competing parties can't agree on anything. And today, Washington, D.C. doesn't get done when it needs to get done. The book sort of implies that opinion is overemphasized and probably not true. We take that up in a much larger degree in chapter 13. And also, seemingly a little bit out of place, the book comments on line item vetoes at the end of this chapter when it is discussed in much greater detail in chapter 14 on the powers of the presidency. The Constitution was silent on whether a president could redact or line out one part of the bill sent to it by Congress and approve the rest. So, from time to time, that was practiced. Line item veto, the executive ability to block a particular provision in a bill passed in the legislature. But the Constitution is kind of silent on it, so it was ultimately challenged in the courts. And in 1996, the courts struck down Bill Clinton line iteming certain things out of proposed law. And even though Ronald Reagan, so that would mean parties on both sides of the aisle, Clinton's a Democrat, Ronald Reagan was a Republican, when they're president, they want that power. It's now determined to be unconstitutional. All right. So what are your responsibilities? Your responsibilities are to know anything I said in this video. Your responsibilities are to read the chapter and know it in detail, and be able to connect any ancillary readings that I have assigned to the topic of the Constitution, which is the topic of this chapter. So that would be it. That video was way too long at 35 minutes. I hope you watched it on time and a half or double speed. That will do it for us. You're done. It's going to take me a second to get out of the video.